started. Good morning, ladies and gentlemen. My name is Fatina Sayed. Welcome to Joliet Junior College. We are the Entrepreneur and Business Center, and we provide no-cost business advising and one-on-one support for entrepreneurs and small businesses. You don't have to be a student of JJC to work with us. You can be in the community or somehow connected to the community. We love to help people. Before we get started, I'd like to just run over a couple logistics. If you have a phone, let's go ahead and silence those phones. Entrepreneurs are busy people, and you're going to get a phone call in the next hour and a half. So let's silence those phones. And then if you do need to use the restroom, it is out the back door and towards the restaurant, down the hallway. Guests, clients, friends, and especially the students from Joliet Township High School, our entrepreneurial students. Let's give them a hand for We are all here because there is some connection from you and a business or an idea that could potentially be your future and your family's future. So entrepreneurship is all-encompassing. And one of the things that I learned growing up from my mom, who was an entrepreneur, is always get it in writing. I don't know where my mom learned this. She came from a small village in the Middle East, in a little country called Lebanon. But somehow she knew that you need to get it in writing. And so I started thinking in that mentality. Some of our clients managed to get pretty far with their business plans or the acquisitions of other businesses. But there's a point at which things could go wrong, or you need a professional to step in and help make sure that you're on the right path. And so we always encourage entrepreneurs to work with resources that they have. You don't have to do it alone. And as a matter of fact, doing it alone could potentially hurt you. We are a resource and we love to help. Manager of the EDC, Brian Kincaid, Jeff Schultes, who some of you know and work with. And today we're very happy to be introducing you to one of our partners, and her name is Phyllis Roman. Phyllis is an attorney, a partner with Giamanco Law out of Bolingbrook. This is an attorney's firm that has won the Best of Bolingbrook Awards or been nominated several times years in a row. And I think the reason that is because they're just good people. They're good people who happen to be attorneys who do a pretty good job. For that reason, we're very happy to have her here with us today to share some information with you regarding LLCs, corporations, what to do with contracts, and different things that she's experienced in her career. The format for our presentation will be that Phyllis will go through her slides and share examples with you. We ask that you hold your questions because we have allocated time for a Q&A at the end. So after Phyllis is done, I'll come back and we'll do some questions of which you shouldn't be shy to ask. You have free access to an attorney, ladies and gentlemen. And then after we conclude our question and answer session, we will have some time for networking. We do encourage you to get to know one another because you never know when you're going to meet that next person who believes in you and becomes a support system. With that, I am very happy to introduce to you Phyllis Roman. Thank you.
So good morning, everyone. I did create this presentation, and most of the examples I'm going to use, because they were kind enough to give me the businesses that you all have, focused on either services or focused on like a retail shop. So things that are going to register on you more regularly rather than someone who may be an accountant who has different circumstances on that end. I did not focus so much for the students here. I'm not sure what your ideas are as far as coming forward. If you're going to have a retail shop, if you're going to be doing more of a social media game or gaming things, anything like that. But the examples can extrapolate out from there. So it's things to make sure that you don't have to come to people like me. So I appreciate the introduction. Our firm we're trial attorneys. So if you're calling us, 90% of the time someone is calling us, they've got a problem going on. So this presentation is designed for the most common problems that I see with either potential clients, people just calling for a few pieces of information, or people who actually end up in a lawsuit and the ways that they could have avoided that lawsuit or at least made the lawsuit significantly cheaper. So that's where this focus is kind of going. There's going to be some overarching things on creating a corporation and things of that nature because you just need that ground rules, but the vast majority of this presentation is based on keeping you away from people like me. Okay? So we got some Atari here. Just as the outline, there are many, many pitfalls that a corporation, an LLC, an S Corp, small business, sole proprietorship can run into. All right, so we're going to go over, there's a lot of overlap on these, but we're going to go over some corporate formation issues. Piercing the corporate veil is, in my opinion, one of the most important ones. So we'll go over piercing the corporate veil to protect your personal assets. Because you don't want to have a problem with a customer and then they're coming after your home and your mortgage. So this is avoiding piercing that corporate veil and what you can do to avoid that particular issue. Litigation costs, keeping them down, keeping them either down or gone and entirely removed. Having insufficient insurance and what that can result in. Contract disputes is the #1 thing that we get. Between small businesses, corporate to corporate, between customer to business, the #1 issue we see are contract issues. So I'm going to give a couple of 101s on things to make sure that you're putting into your contract to try to avoid issues. And then employee disputes, I'll do a bit. I'm not that's a very narrow area of law where you're running into the EEOC and federal courts. It's a little different, but I can give you a couple of basic ground rules on the employee disputes. I want you to be thinking about these details now rather than calling me when you've been sued with a $50,000 lawsuit saying, oh my God, what do I do? If you think of it now, we can get you out of it cheaply. For example, I used to work for my father in high school at a blue-collar manufacturing firm. They would purchase millions of dollars of steel. Millions and millions of dollars of steel to create dams in Korea on a tiny little piece of paper this big. Just saying, this is the amount of steel we're buying for this amount of money. That is it. That is terrifying for someone like me. It has no time limits, it has nothing. And they ended up in a lawsuit because of it. This business is great when it's great, right? But think about it in advance so you don't end up with millions of dollars of steel with nowhere to put it. Okay? All right, so corporate formation is going to be kind of our first one. The #1 thing is forming it, right? If you are not forming the corporation, that means you individual, you Joe Schmo, are on the hook for everything. So that if I come forward and sue you because your customer, you're a nail salon and you burned off the tips of her fingers because you had bad product and you didn't test the product in advance, and I represent the person suing you as a company, you've created a sole proprietorship of, Jane Addams Nail Salon. But you didn't make a Jane Addams Nail Salon LLC, I'm not coming after you. I'm coming after your 401k, I'm coming after your home, I'm coming after any assets I can get because my client lost her tips of her fingers. If you create you form the corporation, we're not coming after you personally. It's just the corporation itself. It has to be a separate entity. You have to think of it as a person. I know it's your heart and your love and it's your time and your effort and everything you've done to create this entity. It is a person. Think of it as your baby. It is an actual physical separate entity that you have to create and treat it as a separate entity. Even if it's named after you, it's a separate person. And the laws support that it's a separate person and give you protections if you create that separate person. To create that separate entity, you have to register, obviously I'm sure you all know this from working here, you have to register obviously with the Secretary of State, with the IRS, sometimes with local governments. It's extremely easy to do, to just register. The bare minimum of the registration, but if you don't do it, you're screwing it up. I have a client that I had who, 27 years, okay? He was a retail shop for food for restaurants. 27 years in the same location. He incorporated his very first year and then never did the follow-up with the Secretary of State. You have to follow up with your annual renewal it's incredibly easy. It's 10 minutes to follow up on the Illinois Secretary of State. He didn't do it for 26 years. Someone new bought out, he was renting, someone new bought out his location. They looked him up on the Secretary of State, because everyone can do it. No, but the first thing that I do when a corporate client calls me is I look him up immediately to see what they are on the Secretary of State, if it's good, if it's active, things like that. They found out that he was not an active corporation, hadn't been active for 26 years, and they kicked him out of his retail location, and they didn't renew his lease. So a 27-year business lost his location simply because he didn't pay the $75 fee and send in one form to the Secretary of State. We cleaned it up, we got it taken care of, but he had to move his location a mile down the road, and it hasn't affected his business long term, but that's a huge change. Moving a location is huge. So make sure that you're creating and doing the registrations necessary. Check with the Secretary of State. They are wonderful. I've even called them. I actually called them up in this client's situation saying, hey, it's been 26 years. The longest I've done is 5 years. Are we still good to just re-up it after 26 years and just submit 26 separate forms and 26 fees? The Secretary, I'm an attorney, I didn't even know. But I called them, the Illinois Secretary of State is a wonderful resource. I had a trucking company who was doing CDL drivers, right? They were doing CDL and they had no idea what they were doing and they got a bunch of fees and fines from the Illinois Secretary of State. They called the Secretary of State and they walked them through exactly what they need. And it's free. It's the Illinois Secretary of State. Your taxes for paying them. You just call them up and ask questions. If you take the time, they will tell you what you need to do. So just make sure that you're calling the entities, right? Most businesses that I saw on the list here don't need additional licensing fees or registrations or anything like that. But certain towns require registration. New Lenox requires a $35 registration for your business. So make sure that you're checking local entities on top of state and, of course, the IRS, because they're going to take theirs. Sorry, let me click here. So you have a lot of different, when you're creating a separate formation, when you're signing your name, right? You're signing a contract, you're signing your registration, you're signing purchase agreements, you're signing anything you're signing, you are not signing it Phyllis Roman, because I am not the corporation. You are signing it Phyllis Roman as authorized agent or as president of, or as whatever your title is, Jim Uncle Law Partners. Because then you're telling everyone, I am not doing this as an individual. I am doing this as the person who's authorized to sign on behalf of this fake entity. Because this fake entity doesn't have his hands to sign it. So we're saying, okay, I'm not signing Phyllis Roman. Because then there's an argument for people like me to make that you meant it as an individual and you pierce that corporate veil. So you're signing always as your corporate entity. Most places won't let you just sign Jim Uncle Law Partners. They want the name so they can tag back to who is signing it. But just sign it Phyllis Roman as agent, Phyllis Roman as authorized agent, Phyllis Roman as president, as secretary, whatever your title is, CEO of that company. Because then you're pulling it all together with and keeping that entity separate. Types of corporations. This could be its whole presentation, so I'm not going to go into it too much. But your major ones that you want, you have a sole proprietorship, my recommendation to you is to avoid that. Because again, that's when they can go after you individually. Your biggest ones are going to be, C Corp isn't really going to come into effect here, but you're really looking at the LLC, LLP, and S Corp. This is one of those situations where you're going to want to predominantly talk to your accountant because most of these are accounting issues. So in a LLC, you're going to run into the fact where each member is taxed. So you have the company entity that's not taxed, and then the members are taxed on the amount that they get. If you have an S Corp, the entity is taxed on just the profit, okay? So there's tax considerations for both of these. There's also considerations if you are a sole proprietorship under a corporation. That makes it easier to do it as an S corp because you just have, it's basically treated as a sole proprietorship. If you have multiple members of your corporation, LLC might be better because you can divvy it out based on their contributions to that LLC. This is kind of what I went over already. Make sure you're doing registration. Make sure you're doing your annual reports. We're going to get into these a little bit later, the accounts and the insurance, but make sure you have separate accounts. The bank account should not be Phyllis Roman. Should be, I have Phyllis Roman for my personal, and then I've got Giamonco Law Partners. You do not want it to be where if I submit a bank garnishment, I got a judgment against you and I said I want to see what assets this person has, you don't want them accessing your private account. You just want it going to your corporate account. So make sure you're keeping it completely separate, right? Nothing should be going into your private account unless you're taking a salary. Absolutely nothing. The other one is termination agreement. Most people forget about this. I can't tell you how many clients I've had who they've had a breakdown in the relationship between two partners, and now they don't know what to do. They never had an agreement for a buyout. They never had who needs to agree to buy it out, who needs to agree to shut down the business because someone ran the business, but it was the other person's idea, and the person whose idea it was doesn't want it ongoing. They don't want this person running it. So you have all of these problems because you didn't consider the end. No one wants to consider the end, right? You're forming this business, it's your baby. You don't want to consider the possibility that this may end in the future. Have it in writing immediately. It should be with your formation documents. As you're forming the business, you should have a buyout, a termination, something like that. We had a pizza client, family pizza client. It was a father and son situation, and they'd actually come to us for the formation, so we had a termination agreement in their formation contract. The son wanted out, wanted dad to be bought out, and said, well, I'm going to give you an offer of $15,000. This was a multiple pizza locations, $15,000 was insulting, okay? And he said, well, we're 50-50, I get to make the decision. You take $15,000 and get out. Well, he hadn't looked at the contract that we had drafted. We said that whoever wants out, if the person who doesn't want out had disagreed with their amount, then it would be $10,000. Basically, as punishment if someone was lowballing. So we said, hey son, you wanted to make this lowball offer at $15,000 to buy out your dad. Well, what ended up happening, he hadn't looked at the contract, and in the contract it had a termination agreement that said if the person staying in didn't like it, they could say $10,000. So we had it down to $10,000, and the son was out. So you really need to make sure that you have it in writing what happens if you end, okay? If you end, if you want to buy out, if there's intellectual property that you can't take it somewhere else, you know, if you've created something here, right? Like, so for me, like as an example, on our things, I have a ton of paper. This presentation, for example, is my intellectual property. If I was to leave Giamonco Law Partners, do I own this, or does the Giamonco Law Partners own this? Okay, this is not like brain surgery. But in the sense that, whose is this? There needs to be a contract to say who owns what. Okay, is it the business that owns it? Is it your individual? All of these things are things you need to think about before there's issues. And it might suck, for lack of a better term, to have those considerations in advance, but you're going to be much happier if it ends in 20 years to have this figured out. And you can re-up it, you can change it at any time, right? So if you have your business start up with nothing, right? You're in your bedroom or a dining room, and you're creating cookies, and someone is marketing it, and you're doing the creation. And then you end up in a commercial kitchen 10 years down the road, you can reconsider all of this, right? Then you hire an attorney and you do it. But that initial startup, it has to be in the agreement somewhere, written, a termination, buyout agreement, something of that nature. Keep it separate, just like your recycling. So this is where it gets into your separate bank accounts with a separate person, separate insurance, separate if you can even create, don't even have I understand if you have a home address is where your business is coming out of, but if you can create a P.O. box, so that's the address, better. Anything you can do to have it separate between your entity and yourself, the better you can do. So you want to make sure that the bank accounts, your insurance company, your location to the extent possible, I understand that that's not always possible. Emails. It is so easy to create your own domain name, right? So my email is phyllis@glawpartners rather than my personal Gmail account. It is so easy to create 2 separate emails. Just create it. Even if it is a Gmail, even if you don't want to create your own domain name, have a separate one for the business. Just so you're using one for personal and you're using one for business. Anything you can do to keep them separate, keep it separate. Any documents should be in the business name, not your personal name, okay? I had a contracting company that I represented who did siding and roofing and that kind of stuff, and they put on the top the company name, comma, like so it would be like Geometrical Law Partners, comma, Phyllis Roman. They just trashed any separation that they had. They just killed it, so that all their customers can now come after them individually, rather than just the company. So it should just have your name. If you're a landlord, you can have it just in the company name, right? It can just be, landlord, company, corporation. It doesn't have to be Phyllis Roman. Everything should be in the company's name. Big one. I actually learned this 2 years ago. Your corporate credit cards. They all have if I was to pull out my corporate credit card, it says Phyllis Roman and Geometrical Law Partners, right? So right here it will say Phyllis Roman and under it says Geometrical Law Partners. You think that protects you, right? You think you're good, you've done everything, it's under the Geometrical Law Partners, the signing was all under Geometrical Partners. All of the major credit card companies that I am aware of, in their terms and conditions now, say even if it's a corporate card, you are on the hook. Yeah, I learned this 2 years ago. I had a client who had a woodworking business, created beautiful woodworking, had a corporate account, significant amount of credit card debt, $48,000 in credit card debt. They filed 2 lawsuits against him. And in the terms and conditions, that small packet of paper that you get that has all this stuff, you're on the hook. So technically speaking, I'm on the hook for Geometrical Law Partners credit card. It's not something you can get out of, to be honest with you. Because Chase, Citibank, they got more power than all of us, right? They're just gonna say, oh, don't use us. It's just something to be aware of, okay? You can check your terms and conditions on your credit cards for people who have small businesses, check it. But I'm almost willing to guarantee that it has it there. That doesn't pierce the corporate veil, it doesn't separate it as far as for everything, for any of the other customers. But if you're not paying that credit card bill, they're gonna come after you personally. All the big banks I know have that. So it's something to be aware of that you actually, that from my knowledge, you can't keep separate. But it is something that you should know. So if you're running up a lot of, then it might make more sense then to do a business loan, right? If you're doing a big expense rather than sticking it on a credit card, and you're doing a big input of, maybe you need, we're in the kitchen here, maybe you need a bunch of Le Creuset that we were discussing earlier. Maybe you need a bunch of Le Creuset to start up your business. Maybe you put that on a small business loan instead of the credit card. Because a small business loan shouldn't have that personal guarantee if you can work with the banker and that kind of thing. Whereas the credit card is probably going to have it on your personal. So just be aware of those things when you're taking out loans. Loans, credit. This is the big one. This is the legalese. I try to avoid the legalese as much as possible for people, but in some respects you need to have it. So in a piercing the corporate veil. Piercing the corporate veil is when people like me go after either separate corporations, so if you have like a parent corporation and a bunch of little baby corporations, or to go after the individuals, right? So you're basically saying this person didn't keep it as a separate entity, therefore judge, they don't get to keep protections. All the protections and all the assets are just under that, and we're kept keeping everything else separate. They have failed to do that, therefore I get to go after them, personally. So the courts are looking at if you have two things. If you have a unity of interest in ownership, that the separate personalities no longer exist, sorry, legalese, and then two, that the circumstances that exist, whatever the dispute is, the circumstances exist that adherence to this fiction that we all create, this fake entity, this fake baby, of a separate existence would sanction a fraud, promote injustice, or promote inequitable consequences. What this basically means is that you've commingled everything. There's no way for me to tease out who these two individuals are, because it's all commingled. You have signing on both of things. You're signing things as an individual, you're signing as a corporation. You have things on your accounts are all commingled. You're using your personal account instead of your Gmail account, right? Like instead of your corporate account. To do contracts, to pay, to contact your employees, things like that. Everything's got to be separate. This is not looking to you, right? It's not saying that it's going to be unfair to you if we pierce this. It's going to be unfair to whoever's suing you. So the one I had on this one where I did pierce the corporate veil of a corporation is there was a trucking company. I was representing an independent contractor. He had his own corporation that he ran as an independent driver, right? This is very common in CDL driving. Where he was running for a company, and the company, every time they would get in trouble with the federal government or IDOT, Illinois Department of Transportation, Federal Department of Transportation, they would shut down the corporation and create a new one. Shut it down and create a new one. Now that could be a great idea, right? To avoid problems in corporations, I would never sanction something like that, but it can be a great idea if you're running into problems with one business. But he was not keeping it separate. He would overlap things, right? And I could trace back emails from one corporation back to the very first corporation, 3 corporations down, because they was using the same email address. He would copy and paste language from one email on his personal email onto the corporation's email. So I was like, this is the same person. Same syntax errors, same errors in the email. So I pierced it and I said, we did it for a gym too. A gym had 4 different gym locations, and each with their own independent corporation. And then there was a parent corporation. My client got injured on one, and we went after all 4 of them. They shut down the one, but they had commingled it so much that I could go after all of them. Now it's hard, it's hard. Piercing the corporate veil is hard. There has to be a lot of overlap, there has to be a lot of commingling. You know, I think I put some of the things they look at. They're looking at the accounts, they're looking at the emails, they're looking at if it's the same business, right? The exact same thing that you're kind of falsifying. But this is the risk, right? If you're not keeping that corporate separate and distinct, this is the risk you're running at, where we're going after you personally, we're going after your bank account. Like if you're married, we're trying to come after your bank account with you and your husband or your wife, right? This is what we're trying to avoid, that, no one wants a business to fail. But if it fails, right, and it happens, it's unfortunate, but it happens, you don't want it to take down everything, right? So that's the benefit of having a corporation, as long as you're keeping that corporate entity separate. Sorry, not political, it's just perfect. You're fired. At will employment, not political at all, just you can't beat the meme of you're fired. Illinois is an at-will state. Don't screw it up for your employees, right? As someone who represents the employer side more often than the employee side, at-will employment is great for employers, not so great for employees, right? If you're an employee, not the greatest. They can fire you any reason that's not protected, race, gender, age, just disability. You can't fire for those reasons, but other than that, you wear peak leggings all the time, you're fired, right? It doesn't matter. But the employer, you as an employer, you want to make sure that you're not screwing with this. Just because you don't have a written contract saying, okay, here's your written contract, you are going to work for me for 2 years and at this rate of pay and these benefits, even if you don't have to sign here, even if you don't have this contract, you can still have a not at-will employment. If you're doing reviews with your employees every year, right, you're like, okay, let's talk about a potential raise, your good things you've done this year, the bad things you've done this year. Chit-chatting, talking. During that conversation, we really love you, we want you to, we know you're going to be here for the next 2 to 5 years, and then we're going to make you a partner. You just killed at-will employment, potentially. Question of fact, all of that. But you potentially just killed the at-will employment, and if they end up having, personal issues where they're not doing their job anymore, now you have a potential contract that you just created saying in 5 years I'm giving you a partnership. So that was an agreement that you made, and they can argue that you just can't fire them for any reason anymore because now there's a contract, so you have to fire them for contractual reasons only. So make sure you're not screwing up the at-will employment. Don't make those promises, right? We love you, we want you to continue working here, great. But don't make contractual promises because oral agreements, despite wanting everything in writing, are contracts. Let me see, I enter. Insurance. I would say, other than piercing the corporate veil, this is probably the second issue that you run into the most. Workers' comp, disability, liability insurance. You must have enough, okay? I can't tell you how many times my clients have either gotten sued and then the person being suing them says, you know what, I know you're a business. I don't care that your liability insurance is $300,000. I want money from you because you're a business and you have it, okay? Normally, if you're in a car accident, you get in a car accident, you rear end someone, and you have insurance 100, 300 with State Farm, right? Most people's common insurance. I'm not coming after you personally. You don't have money. This person who you hit isn't coming after you for in excess of the policy. But a business, people see your chicken. It doesn't matter, they don't see your profit and margin books, they don't see how you struggle to pay your suppliers. They don't see that, they just see there's a business who has money. So unless you have enough liability insurance, they're coming after your business at that point, and the profits your business are making, and you're gonna have to put up money. I've had clients who have had liability insurance of $300,000, which you would think is plenty, right? You would think is plenty. But if they have someone who has a severe injury, they slip and fall at your property, and you have a broken hip and brain trauma, $300,000 is not enough. It's just not. So then they go after you individually, and you have to put up out of pocket another 50 grand out of your business expenses because the insurance isn't enough. Same with work comp, right? I have many small businesses that I represent in work comp cases, right? They did not have work comp insurance. Now they're being sued by an employee for minor injuries, right? Minor stuff, but they can sue them. And now they're paying me to hire experts, to hire doctors to defend this. Instead of just having the work comp insurance where these people on, I don't have these on standby. I have to go find a doctor in the community, pay them thousands of dollars to represent and inspect your employee and see if they're actually injured. Whereas if you have work comp insurance, they have these doctors ready to go, right? And they're automatically, from the get-go, saying, okay, you're going to this doctor immediately, right? And they're protecting you immediately. Whereas normally, you're contacting me 6 months down the line saying they've already gotten all this treatment that was necessary. And I'm like, well, I can hire a doctor now to refute that, but it's done, We actually represented the injured party in one. We're liable to pay $1 million in coverage. $1 million! And we still got $35,000 from them because they killed someone. Right? $1 million isn't enough. Now, it generally is enough. If you get $1 million in coverage, the likelihood of having a death on the property is extremely low. But it's just never going to be enough. So the more insurance you can have, the better. Because then you have attorneys protecting you, right? Because your liability insurance is hiring people like me. You don't have to hire me. The insurance is hiring me, covering all of the costs and dealing with everything. The insurance is absolutely necessary. The employee issues probably should have been on the last slide. Sorry about that. Record maintenance. Not a lot of issues here that I run into, but just to kind of mention, keep your private information separate. So if you have an employee form if you have an employee file, keep them separate. So if you have health information or social security numbers, things like that for your W-2s, keep them separate. Even on your own, just keep everything separate from reviews or, if they're sending you a letter or write-ups or anything like that, just keep those separate so that if you're handing a new supervisor, if you've gotten to the point where now you have 2 levels, you've got supervisor says, I want to see that employee form, or an attorney wants to see that employer form, or the state or whoever it is wants to see your employee form, you hand them the general things, you're not handing them health information or social security number, things like that. So just keep them separate. It doesn't normally run into issues, but as an abundance of caution, keep them separate. Non-compete just changed. It used to be, it had to be reasonable in time, duration, you couldn't say you can't work in this industry. I know I met, Brenda earlier, and she's a sewing shop locally here. You can't say you can't work in a sewing shop over in the entire world, right? So the non-compete used to just be reasonableness, reasonable in time, reasonable in duration, reasonable in location. Now, if you make under 75, there is no non-compete. So the non-compete clauses are much, much harder in Illinois. I should say this is an Illinois thing. You have to have 75, you have to make $75,000 a year. You have to be working there for 2 years. You have to have some or consideration. So if you're only working for 6 months, but they paid you $5,000 to sign this non-compete, you say, okay, employee, I don't want you taking my cookie recipe, or I don't want you taking my, if you have a nail salon and you have particular things that you do different from anyone else, I don't want you taking this somewhere else to another place you're going to compete with me with, give them something for it. It hurts, but give them, then you have a consideration. You need to pay them to not compete. After 2 years or after $75,000, then that kind of goes out the window and you go back to reasonableness. And the reasonableness all comes down to the particularity of what you're doing, right? So the more particularized, like if you're a neurosurgeon, right, they can give a bigger time in a bigger location. If you are a McDonald's worker, you basically get nothing because everyone can do it, right? So the more complicated, engineers, right, are going to be more, depending on the type of engineer, you can do a bigger distance in a longer time. Firing. This is kind of where you're getting into the federal stuff, but I have a couple of do's and don'ts for firing people because it happens. It sucks, but it happens. You need to, on the next page, give a brief reason why. You don't actually have to give any reason, but as long as the reason is not for a discriminatory fashion, you're not saying because they're race, not because of their gender, not because of their age, if they are always late, give a very brief reason and just say they're fired. Have your paperwork ready for them. You have no obligation to give them any paperwork. Have them, this is when we'll give you the last paycheck. This is when we'll give you the severance package if you're doing a severance package. Here's how you maintain your medical. Have it all ready to go for them in a package so you're not constantly contacting them. So firing is fine. The way to avoid a lawsuit over it is to keep it very brief with a very simple explanation of firing. Okay? Long explanations, they can just start, well, they said this and it wasn't that, and they were hiring, if you start saying things beyond like you're late all the time. If you have everyone at your place late, and you're firing the one minority for being late, you're gonna get a lawsuit, right? You just are. So you've given that reason now, and someone can now say, well, you have fired none of the white people, and you're firing your one minority. So it's good to give a reason if you have one, but keep it real brief and make sure that you're not doubling down, right? And that you're treating them equal. You should be treating everyone equally. This is discrimination. I don't do discrimination lawsuits, but just as a human being, don't discriminate. Just don't do it. You're gonna get a lawsuit, it's awful, just don't do it. Verify everything. The number of times I have clients employers call and say, well, I thought they had their own insurance and they didn't. Get the paper. Make them give you the paper. Right? That's not insulting to them. It's not unexpected to people, right? Like, I have to prove I was a licensed attorney. Sort of. It's registered on the Illinois, like, you can look me up on the Illinois A or D, C, but prove it. If you want them to have their own work comp insurance, okay? So you're doing a wood making thing, and you have your own carpenters, and you want to make sure they have their own work comp, verify it. Don't let them say, oh yeah, I've got it. Get the paper and re-up it, right? So we have malpractice insurance, right? And the Illinois, my licensing body, confirms a copy of it every single year. They don't just trust that I have it. They're like, let me see it. Same thing for anything you need, right? Like I'm not familiar with all of your businesses, but like if you have a licensing issue, if you have an insurance issue, if you have whatever you need for your business, this is your personal business, verify it. If you need a particular license to be doing things, if you need a forklift license to be doing the warehouse, get it and constantly re-up it. Don't just trust them. Let people be trustworthy, but it doesn't happen. Contracts, bread and butter, get it in writing. But oral agreements are contracts. Let me say that again. If you make an oral agreement with someone, it is a contract, and it is enforceable by law, by a judge, with damages and everything. Just because it's not written down doesn't mean it's not enforceable. Now, it's harder to enforce, and you got a he said, she said, and who comes off better at trial, all of that kind of thing. But they are contracts. The number, I've been doing this 12 years, the number of people who call me and say, well, there's nothing written down, I don't care. You agree to it, right? Loans between friends, forget small business. You loan your brother-in-law $15,000, no written, doesn't matter. I can sue you now. It is a contract. Now, that said, written is better. Please, written is better. But oral agreements are contracts, and they are absolutely enforceable. Yes, everybody. Modifications, again, in writing. Make sure it is in writing. Any modification. Number one, I don't remember if anyone was in this area. I don't think I saw anyone. The number one area where people screw up on this, and it could be as you doing a build out of your business, construction. Whether you're hiring a contractor to do a build out, whether you are the contractor to do a build out, it is constantly not in writing, right? You're changing the tiling or whatever it is. The number one error I see on modifications is actually in contractors, contractor businesses, or business hiring contractors. We had it wasn't USPS, it was some postal shop. Same thing, had that issue, right? They'd done build out to upgrade their location, and the contractor, they were constantly doing changes. So modifications must be in writing. Parole evidence rule, this is one that gets people every time. So we enter into a contract, right? We're business to business. I'm going to be providing you, I'm sorry, I just met Brenda, so I have the sewing shop on my mind. You're going to be coming in and servicing, you're hiring me to service all of your sewing machines, right? I'm coming in, I'm servicing all your sewing machines. We have just a regular ongoing contract saying, once a month, I'm going to come in to just do maintenance on them, and then if you have a particular spot issue, I'll come out for this blank amount of money. We're doing this, we put all that right in, right? Monthly, $500 a month for me to come in monthly just to oil and tune them up, and then on a spot basis, $250 to come out, and then whatever the cost is to fix the actual sewing machine. Great, all written down, we sign it, beautiful. We talk while we're doing it. Well, I think we should always come out on the first Monday of the month because that tends to be really slow time for me. And I know then that you're good for the whole month, and holidays tend to be at the end, so let's always do it on the first. You don't put it down. Parole evidence says you can't bring it up in court. We go to court, and I don't come on the first, I start coming on the 5th, and then I'm coming on the 10th, and then I'm coming on the 15th, and then I'm coming later and later and later every month. You go to court to sue me because I'm breaching the contract. Based on your agreement, I'm breaching our contract. I'm not coming on the first of every month. It not only is not part of the contract, you are barred from representing it at all. You can't even tell the judge that we talked about that. Parole evidence says any oral discussions that occur around the formation of the contract, if it's not written in the contract, do not come into evidence, period. 4 corners of the document. So if you're saying it, put it down. I had a sale of a business that occurred where they were just selling basically the license. It wasn't a license, but they were essentially selling just the authorization to operate. not the bank accounts, not the stuff, not the stuff of the business, just the authorization. And that person was going to continue working for the business, until they decided they didn't want to work anymore. None of this was in writing. It was a one-page contract, and they lost thousands of dollars because the person took over the bank accounts, because the bank account rightfully was in the business name. It was Giamanco Law Partners. As soon as she sold the business, you can't sue on that bank account because that bank account is now no longer yours, right? Because it was the corporation, and you sold the corporation for the $20,000 that was sitting in the account that you earned, and you did the work, poof, gone. Even though they had this discussion, she lost 20 grand plus other stuff, but she lost 20 grand in an instant. We tried, I ended up losing. That was when I lost. I tried to fight for her because of 20 grand. Yeah. Here's. So this is a really big one that people don't know, right? Attorneys know it, but Joe Schmoes don't know. Authority, make sure you have authority to do what you're contracting, and make sure they have the authority to do what they're contracting. I have someone who wanted to be an employee, right? And he talked with the chef of a golf course and thought he was hired. The chef doesn't have authority to hire someone, right? Make sure that whoever you're contracting with has the authority to, what's the word I'm looking for? The authority to bind that corporation, right? That one I haven't run into much, it's just the one time, but authority, make sure, right? Don't be a jerk. Just don't, right? You can avoid a lot of me and a lot of the issues if you are not a jerk, okay? So you don't want to lie. Falsifying evidence is not a good idea, and you will be caught, right? You don't want to do fraudulent inducement, right? Puffery is fine. The legal term, I kid you not, is puffery, right? The case law says puffery. So, this is the greatest car ever! You must buy it! It's amazing! Totally fine. This car's never been in a crash, it only has 10,000 miles, you absolutely should take it. Not fine if it's false. So, there's a case law that says you know porn when you see it, similar to puffery, right? You know puffery when you see it, and you know it's a specific example. So don't be a jerk, don't lie. Talk up your business. Your businesses are great. Your product is great. Your services are great. Talk them up, but don't lie, right? Don't promise that you can get something in a month if you can't, okay? That's where you're gonna get in trouble. Legal fees. If you take nothing else from this meeting, put it in your contract. Illinois law does not allow you to recover my fees unless it's in your contract. You can't, so if you have a $4,000 contract with someone, right? Someone purchased stuff for you, purchased clothing, purchased whatever happens to be for $4,000, and then they stick you on the bill, you're not gonna hire me. It's not gonna be worth it. You're gonna pay me close to that amount of money to get that money back, and you can't get my fees back. Any of your contract, if you have a one-page purchase agreement, that $1 million, the steel thing I mentioned earlier, there's one line. If I have to collect with legal fees, I can recover them. That's it. Add it to any of your contracts, because then you can go after my fees too. If it's not in the contract, you can't get it. And it's going to make a lawsuit, generally speaking, unless you have an excess of $10,000 worth of damages, it's going to be useless to hire me. Cost-benefit analysis isn't going to make sense. Put it in, and then you get it, okay? One line. 4 words. I can recover attorney's fees and costs. Done. That's how HOAs get around it all the time. HOAs, you have a $250 HOA fee you haven't done, and then they get, $3,000 of attorney's fees. Okay, similar concept. Simple language, don't try to sound like an attorney. I don't even want to sound like an attorney. Simple language in your contracts is better. Any language in a lawsuit is construed against the drafter. So if you're drafting it and it's confusing, and/or, wrong commas, things like that, it's construed against you. The court is going to say, well, you drafted it, so we're going to go, if it's confusing, we're going to go in favor of the person who didn't draft it. That changes if you both have attorneys. that doesn't really apply. But, so keep it simple, stupid, you know? All right, sorry, a lot of language on this one. What do you put in the contract? Simple, in that simple language. Both parties agree what you're agreeing to, right? Kind of basic. Make sure it lays out everything, right? This is back to that parole evidence rule. You need names, names, just your business name, not your personal name, identifying information, details about what it's agreeing to. You know, here's one where Naperville J. Sealy's are buying $200 worth of toilet paper. It needs to be specific, right? You need to identify everything that is part of the contract. If it ends up being a 5-page contract, it does, okay? When is payment going to happen? When is the event going to happen? When is everything going to happen? Termination clauses, right? On that sewing example, if I'm doing this, what are we agreeing to terminate? If I'm not repairing it correctly, how are we agreeing to terminate? Do you just send me 2 weeks notice? Do you send me 2 months notice? Right? Because if I'm if you want it easy, just I send you a notice, I'm done. I am basing my business based on this, so I want a longer termination notice because I've accounted in my small business where I'm doing repairs needs a longer termination so I can plan a new one. So you gotta agree. Is someone violating it? All right. Legal fees. Don't write lawyers. Sorry, lawyers are dumb. They try to be, this time of the presentation gets boring. So we say lawyers are dumb. This is true. Don't sound like us. Use short sentences. There aren't periods, right? Commas change it up. It's better to do a period. Don't do comma, what is that, the Oxford comma, where you do A, comma, B, comma, and C. Do the comma, right? If you do, I want, let's see, like red, comma, flannel, comma, and shirts, or do you want red, comma, flannel, and shirts, right? The commas are important, so keep it as basic as you can. In fact, don't have another attorney read it, have your spouse read it, right? What does this say to you? Don't tell them what it's about. Say, read this contract and tell me what the terms are. And if they can't tell you what it is, it's a problem, right? You don't even have to hire me to do it. Just have a friend, right? Have an adult child, have whoever it is, just read the contract and tell you what it's about, and if they can't, move along, start over. The last thing I would say, question, comments, all that kind of thing, but many attorneys, you don't need an attorney for everything, you really don't. But, especially when you're just starting off. But a lot of attorneys do free consults, call, right? Call and just get some information. Or they'll do an in-depth for 1 hour, right? Where you bring everything, you do a flat fee for 1 hour and you can get information, right? Because this is just the overview of everything. So if you have a narrow, particularized issue, just call an attorney and don't rely on one, right? I do debt collection defense, so like credit card, which isn't here, but I can't tell you how my clients call me and say, well, they told me just to come up with a payment plan. No, we can get the debt wiped for you, right? We can get it normally wiped, like a not guilty, you owe nothing. So talk to multiple attorneys, because people have different opinions, right? So I can tell them, you pay me a flat fee and I can likely get the case dismissed. This person says you got $15,000 worth of debt, you come up with a payment plan. Those are 2 different attorneys. Feel who you are comfortable with, right? Some people might not like that I'm a young female attorney and kind of frenetic and, joking around. Some people might not like that. So don't hire me. Hire someone that you feel comfortable with and confident that is going to answer your questions. Okay? Thank you.
Everyone, let's get started. Raise your hand if you learned something new today. Seriously. I do want to tell you, this camera is not functional, so do not be shocked. Okay? We're filming just up here. I know I have a few questions, but I would love to give you an opportunity to either share a comment, something that you're concerned about, or a question for Phyllis.
So I'm a barber, and I wanted to know if non-competes actually stand in the hair industry. Like, can they come after you,
So it can. The law did change. So if you're making more than 75, yes.
Okay.
If you're making less than 75 in a year, and you've worked for less than 2 years for them, generally speaking, it's not gonna stand, unless they gave you something in exchange for signing a non-compete. So if you sign a non-compete, they gave you 10 grand saying you're not allowed to compete in the barber industry in my circle around, in a 30-mile radius for 5 years, whatever they wanna phrase it as, and here's $10,000 to do that, then yeah. It's all a reasonableness standard, but it did become harder to enforce those 2 years ago.
Okay, thanks.
Well, first of all, I appreciate the presentation. You were really good.
Oh, thank you, I appreciate that, thank you.
I enjoyed it.
I try to be flippant, and I try not to be too flippant.
It kept our attention, I think. But I'm a small business owner, a ladies dress shop right down the street. And I'm a sole proprietor.
Yeah.
And I had the business for about, it's going on 6 years. And I would like to incorporate, but I have not done that. I haven't taken that step yet because I don't feel it's big enough. I haven't, accumulated as much revenue as I'd like to see. So what is your opinion, or do you suggest someone should?
Immediately.
Phyllis, let me repeat the question for
Oh, I'm
those who
sorry.
may not have heard it. Ms. Diana Jarvis owns a boutique here in town, and her question to Phyllis is, right now she's a sole proprietor, and she hasn't taken the step to incorporate, and she's wondering at what point does that become important and necessary?
My position is immediately. So if you make S-Corp gets complicated as far as accountantship, but if you're getting a basic LLC, you register with the Illinois Secretary of State, it's $75, and it's a one-page form, right? And then you have to create your other bank accounts and things. And for a dress shop, maybe you're not running into things with like, most of your stuff is going to be covered by liability insurance if someone slips and falls on a defect in your floor, or if you have an employee who, gets tries to say it's a contract instead. So a lot of the stuff, they're not going to be coming after you independently. But right now, if anything happens that you call me. And I will say, I'm a trial attorney, so I automatically think the worst. So I will qualify that a bit. But I can come after you, right? I can come after your house. I can come after your bank accounts, not just the business. Now, if you have enough liability, you can offset that a bit with enough liability insurance, with other things, so you might not have to. But I find it to be, there's just so many protections, right? It's just like this wall that ends here. So if something happens and it fails tomorrow, none of your creditors, and I don't know your individual, but none of your creditors, the lease, your lease tenant hold, as long as you don't have a personal guarantee on it, like as long as you're not signing the personal guarantee saying yes, I'm also responsible, it all stops, and you still have you, right? So, and it's so easy to do the LLC, right? S-Corp has tax ramifications, and there's tax ramifications for all of them, but S-Corp is more complicated. The LLC it would basically treat it as a sole proprietorship, because it's just you, but you have all the protections of a corporation. I actually consider just as an individual, instead of being an employee, to be as a corporation, just to have those protections as well.
Yeah. Okay, thank you.
I'm in the food industry, so let's say I have like a sweets shop, and the space next to me opened up and I want to expand. And I have this shop with me and I'm like, okay, we're about to expand, I want you to do this, this, and this, and then I happen to fire the shop. Is that an oral contract for what you're saying?
Yeah, so I'm going to flush out a bit more, because I will say this, attorney's favorite response is, it depends. Yay! But to try to at least, we're not lovers of hypotheticals in general, but you're like, okay, we're going to expand here, I'm going to have you build out you're going to be doing these cakes only, we're going to hire another chef to do that. So it is technically a contract, but you're presumably firing him not just because, for a reason.
Because it just isn't working out.
Right, like there's something where he's a bad employee or there's a personality conflict, that would, it would trump it, first of all, so I would say you would be fine, but when you're making that, being like, assuming we're still employed here, this is what you're going to be doing, phrase. Because it is a contract, but just qualifying it a bit, you don't have to be mean about it, but qualifying and saying, oh yeah, when you're working here and when we build this, you're saying, you're making it like there are precedent steps to that occurring, right? Like you have to still be working here, we have to then be expanding in order for that contract to come into play.
Okay.
Does that help?
Yeah.
Sorry, I think I'm real close to it.
So I'm in a very unique situation. I have a motorcycle shop.
Okay, great.
My uncle is my mechanic and his business is contracted in to do service work.
Right.
So I most definitely need a contract stating his pay structure, all that good stuff. How would I go about, say one day I'm like, okay, you're not billing enough hours, you're not turning out enough work. What happens when I go to terminate him or fire him? How does that?
Has to be in the
work out?
contract, because you're not firing him, you're terminating the contract. So your contract, like I said, somewhere in there, your contract should have termination in it. So like if we had that's very similar to like what I was talking about, the repair estimate, it's actually just sewing machines versus motorcycles. So you want it in there that you have to maintain this level, or we can or it's considered a breach of contract.
Okay.
Now that doesn't mean you have to terminate it, right? So like if you say you have to bill $10,000 a month, right? Or it's considered a breach. And if you breach, I have the right to terminate, right? And he should have in his side of it, you can't terminate me unless there's 2 months of bad bit, but you want it in your that's why you want it in the contract. Yes. You want it in the contract to say what constitutes a breach. Because if someone else breaches the contract first, you're not breaching, right? If someone else breaches, that's a defense to their breach of contract. I've put that in a million times saying, you breached first, so we didn't breach. You terminated this contract when you breached it. So you want that termination in
So I
there.
can let it go, and I can let it go as long as I want until I decide, okay, I'm not making any money after you need to leave.
Right.
Okay.
I would put in the contract saying that, I have the right to terminate this contract.
So to clarify, for those of you that
Sorry.
yeah,
Yeah.
Jada owns a motorcycle shop, and she has someone who works for her, but that person is not an employee. They're an independent contractor, essentially. And so the question was, can I still fire that person? And you just heard Phyllis's response, you have to put it in the contract from the beginning, under what circumstances you can terminate it. So it's a little different, but that contract still gives you the right to fire them. Any other questions? Okay.
Can I piggyback off hers? What if they didn't have a written contract? What if it was just all oral? And then she was like, well, you didn't do this type of
You're
work.
gonna end up seeing me. You just are. Because that's like the pizza one, right? Like they hadn't had that and son wanted father out, right? They hadn't had that termination, and when I was reading it out, I think I said the phrasing different. It wasn't that they didn't agree. If it was below market value, got it for 10. Not that, because you would just say I don't agree no matter what. But you're gonna end up seeing me. Because he's gonna say, no, you can't fire me. Now, you're probably gonna be fine in the sense that you don't have to keep a contract, right? Like you don't have to keep someone that's not making you money, right? But you're gonna probably want an attorney to come in at that point and say, here's the agreement. And my recommendation is probably gonna be to avoid a lawsuit saying that you breached the contract, you breached our oral agreement that you're gonna use me and no one else, because that's what he's gonna say. I would say you want to hire me to write up a new like a severance package. It's not severance because it's an independent contractor, not an employee, but you want me to draft up something saying, all right, we're gonna pay you I'm just making up numbers here, right? We're gonna keep you on for 4 more months and then we're moving on, or whatever agreement you can come to.
So the good news is that there is a way out of situations,
Yeah.
no matter how dire it seems.
Oh, yeah.
You may need an attorney if you had not involved one in the beginning. So now we have 2 questions. We're going to take John in the back and then the young lady up the front. Okay?
I have a question about waivers. So if I'm teaching in my shop and I'm an LLC, a stained glass or a blown glass class,
Oh, cool.
and I provide you with PPE, I
Right?
provide you with a waiver, what is my actual protection from that waiver and what needs to be contained in it?
So, no. Those waivers, they're not really worth the paper they're printed on.
That's what I kinda
Have them sign it. I always say sign it. Because if nothing else, you're putting them on notice. It's more you're giving, the waiver is not, you're waiving all potential, right? You're putting them on notice that there are risks, and if it's you are assuming this risk by attending this class. If it is a risk that is not normal, okay, like or expected within that And I'm sorry, I don't know the normal risks of that, like a burn would seem fairly normal. But if I'm falling because you have an uneven level, right, that's not gonna be covered by that. But if it's an assumed risk, like if I'm skiing, you're gonna tear up your knee, right? I was actually a personal injury client who chopped off 4 of her fingers because they had removed the protective, I don't know,
Right.
you know, they were cutting something, they removed the thing, and it was a first time thing. Normally that would have been an assumed risk, but they had altered the saw and removed the protective covering so that her fingers could go in and they lose. So the waiver is not going to waive it, it's more you're putting them on notice of an assumed risk. So keep them signing the waiver, put the types of risks, say this is a non-exclusive list, but this is an example of the things that could occur.
Okay.
And then you're just putting them on notice that you could get injured.
So the boilerplate 1 through 5.
Yep,
Okay.
yeah.
Thank you.
Yeah, you said you were an attorney, right?
Yes, 12 years. I wasn't, this is arguably, not practicing law, but it's squidgy.
This question doesn't really have anything to do with the presentation, but college, like what major courses did you take to become an attorney?
I was a dance major.
The question was, what path of education, what classes did you take to become an attorney?
So I was also a poli-sci major, but to go to law school, I would argue I took common law and that made law school a little easier first year, but outside of that, actually being a dancer was more helpful than my poli-sci classes, except for common law and undergrad. Because dancers are a lot of hours, you know what I mean, a lot of stress, and so it's more of a personality type of being comfortable with lots of work and a lot of time. It's not so, and being, you know, I'm a trial attorney, so the dance helped on that respect because it's a performance, but if you were doing some other type, other type of law, dance probably wouldn't have been as helpful. But the undergrad is whatever you feel, whatever you like. There's business majors. I had my best friend was an international studies major, and she's doing probate law now, so not even international law. I would say it's just anything that makes you a good writer and good to analyze things.
Great question. Brenda?
When you're starting out a small business,
Yes.
do you purchase just general business insurance, or should there be specific type of insurance that you purchase?
So liability insurance is the number one. That's a general, if you have an injury on your location, right, general liability is the number one because that'll get you most issues. Work comp if you have employees. If you're gonna have independent contractors, confirming they have work comp, like actually confirming that they have it, even that doesn't 100% protect you because work comp insurance is, even if you're listed as an independent contractor, if you basically are an employee, right, the person controls your stuff, like your tool, they just call it tools in work comp, but your tools, your hair salon is a great, example. I was like, there was someone here, and I was like, but the hair salon is a great example. A lot of those are independent contractors, but they probably are employees for purposes of work comp because you control their hours, you control their location, you control almost everything about it. So if you're basically an employee in everything but name, they're an employee. So I would say general liability, and then work comp is probably the second most common one. Disability insurance is just, that's not necessary, it's just nice to have for your own sake too if something happens, you know. But those are the two, the number one is general liability insurance. Sorry, I'm sorry, I'm running this around.
I have another question about oral agreements. Since they're not written down, like how do you usually go about them?
Oh, you just have them testify. So this is the thing where TV has been terrible. Frankly, even attorneys get it wrong. I yell at attorneys all the time. Like, you have no evidence. Yes, I do. My client's testimony is evidence. My client's standing there and saying, our agreement was A, B, and C, right? I agreed to loan you $15,000 to start up your business and you agreed to pay me $30,000 back, even if it was 5. That's evidence. And then you just would say, on the other side, no, I agreed to 5,000. And it's up to the judge who they believe more. That's it.
That's why you get it in writing.
Yeah.
Yeah. I have a question
Please.
that may benefit some of our students or service-based businesses. If you are doing a service, for example, web design or social media, there's a fine line between feeling like you as an individual are providing the service at what point, is there an income level or a work level at which you should go ahead and get that LLC?
So that was similar to the question here. I genuinely, this is the attorney in me and not the business owner, right? Because the attorney in me says as soon as you start doing work, get that LLC. Because it's so cheap and so easy, and I know the protections that occur. Now, I don't know that there's a particular, I think the particular level where you want to make, not very much certain, I was going to say, we're in a nice presentation, but you want to make sure you get it, is when your risk level is beyond your personal capabilities. So if you're doing contracts for web design or marketing design, marketing platforms for someone, and they're normally like $500 contracts, you can eat that, right? You can subsume that pretty easily as an individual, right? So whenever that pain level gets to the point where you don't want to take that on as a person, that would be the yes. So my initial reaction is do it immediately, but even if you're on a service level, when that pain level gets to the point where if this goes downhill, do I want to take on the costs? That's where that pain, if you're like, no, absolutely not, that's where that level hits.
Very good. We'll do Mike and then Kurt.
So, I started a retired business. I went LLC immediately. And the whole business pretty much is selling things online and having it auto-fulfilled from a different location.
Okay.
The different location sends it out.
Sure.
Possibly, maybe sell pictures in the beginning, at some point in the future at a craft show. But as far as like insurance goes, what realistically kind of liability or insurance do I need?
Because it's in your, like you don't have someone coming to your location. So
If
you
it
have
was
a lower
yeah.
top risk level than most people. If you have it, on yours, it really would just be any, you would just want general liability insurance. You would probably need a lower amount, frankly, because you don't have people, right? It's all
Right.
online. So you just want just a general insurance policy. So I'm not an insurance rep or salesperson, whatever the title is. But you still would probably want minimum 300, just in case if there's anything that really happens. Also, frankly, you, right? Because you are LLC. So if something happens to you, long-term toxic exposure to the folks, if you're doing
Right.
some dark work or anything of that nature. So you want it also for you because you're an employee, right? If you're not, because the business is a different entity, you could theoretically sue the business, right? So yourself, and then we're really just be going after the insurance money. You wouldn't be going after you, right? But you would want the insurance money, and that's why you pay for insurance. So you would just want a general insurance policy just to cover, almost like as an individual, you would get an umbrella policy, similar to an umbrella policy, but for a business. But yeah, you probably don't need that.
Phil's touched on this, but we at the EDC always advise that you have a different commercial insurance agent than the one that you buy your home or car insurance from.
Because they generally don't
They're-
do both.
Yeah, they're two different kinds of insurance
Right.
contracts.
Very few insurance policy people run both.
Right.
Yeah.
Kurt?
Alright, I currently have an LLC,
Okay.
and I am in the food industry. I'm a caterer, and my specialty is barbecue. So, I also have my own line of barbecue sauces and rub.
Mm.
Okay, and this spring I'll be pivoting into a food truck. Okay, so now do I need an additional LLC for the sauce and the rub?
So your call. Where this runs into, this is where that piercing the corporate veil. So this is more, I would say, predominantly a business question. But what I would say, more for on their line of it. But the LLC, it gets more complicated because you have to keep it separate, right? Every LLC you have to keep separate. So if you have multiple LLCs, the same way that you're keeping it, the wall between you and that LLC, you have to keep it between every single LLC. But if the sauce and the rubs go under, right, it doesn't survive, it won't take down the other one with it, right? So if you paid a distributor, you have a contract with a distributor to start manufacturing these on a larger scale, larger quantity scale, and you don't have the sales that you expect. I'm sorry, people call me and it's bad calls, so I always think bad things, but we're thinking good things. But this happens. then you can't make that contract, they can try to go after any assets of that LLC. If you have it all under one umbrella, they can also go after your food truck, and they can go after your catering business, anything like that. If you have it separate, they can't. So it kind of depends more on your tolerance level for the extra paperwork, because that's time and effort, right? I don't need to minimize that, that is time and effort and money. My partner has 2 corporations, right? Like, because he owns a couple buildings, and then he we have the law firm. So, and he keeps them completely separate, right? But yours more overlap, right? There's more overlap with what you're doing. So if you have the tolerance for the paperwork, the protections are there. If you're not so worried about that, and it all under one umbrella is good. If you're hoping it expands writ large, 2 is probably better. You have your overarching corporation, then you have your food truck, you've got your catering, and then you've got the rubs and sauces.
Would you recommend you have a separate email address for each of those?
Yes, anytime you have, it would be like, we get faxes from Leonetti's, and then we get faxes from them, so Leonetti's would be like catering at Leonetti's, or it'd be food truck at Leonetti's, or it would be sauces at Leonetti's, right? So you just everything like that trucking corporation that I hammered, it was the same one over and over and over again, right? They would sort of change it, but it constantly overlapped. Like I could see company A, company B, company C, company D, and it was just, there was so much that just swoosh that they couldn't keep it separate.
We have a student who has a question. Yes?
I want to own a hair salon.
Awesome.
And I want to know what can I do to protect my employees, me, and also protect my customers.
So as far as from, protect them from what?
Like, I want to specialize in hair, so if the decolorant like burns or something like that.
So I recommend, so that's more on the product liability side. So you want to test every single one before you utilize it. I've had clients who have had product that went bad and then they utilized it on customers because they didn't test it before. So you're going to test it before so that you can say, you always want policies and procedures. My policy and procedure is to always check the coloring. I test it on a small piece of hair every single time so I know it's good, right? Then if someone sues you because they have a problem, you're like, no. It was something you did. You put a product on it that interacted with it badly, but that's not my fault, right? That was something you did at home because I know I tested it one day before I put it on you because I always test it on you. So for things like that, you want policies and procedures in place for protection, and follow them, right? So write them out so you could say, hey, every employee, this is what we're doing to protect us against lawsuits and to protect our client. We don't want our clients' heads burned. Like it's not just to avoid lawsuits, it's also because you're a good person. You want to make sure all the policies and procedures are let out and that you're following those. And as long as they're following those policies and procedures, you're going to protect yourself and your clients.
Thank you.
Gentleman in the back.
Okay, I have a real estate and property management business that I operate, and I have a question about insurance and also employment agreements. So I have general liability insurance and E&O for myself, but I don't have any W-2 employees right now. But I have a person that comes in and does 1099 contract work for data entry. I have another person for accounting, and then I have a maintenance manager.
Right.
So my question is, do I need to have workers' comp for those types of employees? And also, do I need to have do I need to have any employment agreements in place for 1099 employees? So
you want an agreement. I would say those ones are actually probably not going into employee because they're doing work outside of yours, right? They're not 9 to 5 at you, they have other clients.
They're like 2 days a week.
Yeah, so they've got other, yeah. So, as long as it is very, like I would have a written contract for them saying that you're not an employee, you have control of when you know what I mean? The more control you give them over their time, the less likely a court is going to find them to ignore your 1099 and make them an employee.
Okay.
So you can't get around employee just by calling them a 1099.
Okay.
So if they're actually an independent contractor who gets to control how they do the work, right? So like if I'm a contractor who's a carpenter or I'm a data entry analyst and you say, this amount of data entry has to be done by the end of the month every month because I need to do it to run rights, right? Then that's, and you don't care when, if they do it at 2 a.m. or at 4 p.m. or whenever, they're gonna be found to be an independent contractor. They can use their computer, they can use whatever software they want, that is gonna be them. But I would still have a contract for how you terminate that contract.
Okay,
Because it's not an employee, so it's not at will, it's a contract.
yeah.
So how you're terminating that and what the damages are, you know, you also want that contract to provide that if they screw up, that they're indemnifying you and that you can get my fees if you have to hire me because they screwed up.
Okay, and then I just have one more question.
Yeah.
If they did start to take on more remote, specifically for the data entry individual, if they started making phone calls on behalf of the business, if I set them up with like a personal line, then I would have to probably firm up our agreements and things like that.
Yeah, you would. The more involved, if they're, at that point, if they're becoming more of an employee, you actually may not even, you may even just want to make them an employee.
Just to switch to W2
Yeah.
and change it, okay.
Yeah, that one is more, like, you gotta check with an accountant on that, because you have employment, you know, there's a lot more that goes into that.
Okay,
But, you're gonna wanna have something where you're gonna cost benefit analysis of, because the more complicated the contract gets, it's probably just better to have it as a W-2, because you have at will and you can just fire them willy-nilly.
okay,
And E&O is errors and omissions, insurance, so like if you're that's a different type of insurance that most people aren't gonna know. If you need it, you know you need it.
We do have time for one or two more
Sorry.
questions.
I'm a talker.
Brenda?
My question kind of piggybacks off of
Yeah.
that too. First of all, I want your card for the barbecue. With the Summer Cafe, eventually I want to bring someone in that does specifically just alterations.
Okay.
So now, as far as the hiring structure, which would be less risky? Have them on as a contractor, or actually hire them as an employee? Because it could be a temporary thing. It might not be.
Right, initially it's probably an independent contractor is gonna be easier, like it's just, especially if you're not gonna have them on, because you have to pay unemployment insurance, while you don't have to have health insurance and things, the industry right now, I can tell you, is you have to have health, you know, you have to have benefits, like it's a employee market, it's shifting a bit, but, you know what I mean, like, so the independent contractor is probably gonna be easily, initially, as well, but the only caveat to that is you gotta give them like rank, right? You gotta give them authority, because they're their own, independent contractors, their own corporation, it's like you're hiring someone, a corporation separate. So as long as they have some sort of authority and freedom within whatever structure you wanna hire them under, then there's little risk there. If they're gonna start being like there from 9 to 5 and 4 days a week or things like that, you're gonna wanna put them under an employee. Yeah.
To piggyback off him, when you said create different emails, like catering ad, whatever ad, then can he put his stuff in an S corp?
So yeah, you can have S corp. So S corp is generally better tax-wise for people. You know, talk to your accountant, but for creation of corporations, it's harder. Like it's just more paperwork and more involved. So you may want to get people who actually do that to do it for you. Really, an accountant more than the attorney, to be honest. But an LLC, you don't necessarily need an accountant to create that. That's why I was saying LLC throughout all of this. S corp, if I was creating, I would create an S corp, right? It's more work and more effort and things like that, but I would create it because of the way it works out. But the LLC is just easier, right? So if you're just starting out and you don't want to hire an accountant and you don't want to do all the accounting that is involved with that and all of that, the LLC can run basically like a sole proprietorship. That's the only reason I've been saying LLC. But whatever corporate form you want, but just creating, if you're creating separate corporations, S corp, S corp, S corp, you know what I mean? If you're creating one S corp and creating members, like you're handling, that's still they're still individual corporations. So if you have a corporation and the members are other corps, they're still corps. You know what I mean? They're still corporations. Sounds like I'm saying corpses. They're still corporations. You still have to keep them separate and distinct. They're just the corporations are members of the big corp.
And then if I do hire an employee, you know, and I do like my payroll on Square, you can do W-2s on Square for your employees. Is it illegal for me to fill out their W-2 for them?
Like, and just input the information?
Yeah, so like, usually it's on a paper, you get a paper, you fill out the tax information, whatever, then they sign at the bottom. Well, on Square, it's on like their app, website or whatever, so there's no place for a signature. If I fill it out for them, is that illegal?
The W-2?
Mm-hmm.
This is This check, I don't know the answer to that question.
Okay.
Because tax attorneys actually go to law school for an extra year.
So here's what
Yeah,
we're gonna do.
yeah. I'm sorry, that one I don't know.
Yeah.
Sorry.
It's okay.
We want to make sure we have time for networking, so what will happen later today or tomorrow, you'll get an email from me, Tina, and it will provide you with Phyllis's contact information, as well as a link to a survey, because we would love to hear your feedback about this event or other events that you would like to see. We would love to get a group picture, so if you are okay with doing that, then I will ask rows 2 and 3 to stay put, and then everyone up front kind of move back, and all the people come to the middle, and we're gonna stand up and put Phyllis in the middle, and Chris here is gonna take a picture.